I'm fucking doing this the day that I went to a conference and saw this horrible shit about like this guy that was executed by lethal injection, and he had basically been abused, I guess, and the fucking cops had his picture of an 8-year-old with like bruises everywhere, and they used his picture to teach the cops how to recognize child abuse. They were executed, and it's really, really fucking sad. And I fucking hate OCA for putting this on the test, because I'm not in family court. I'll never work in fucking family court, so I shouldn't have to fucking read this shit. Severely abused. I'm going to do that one first. Okay, 1, the child has been found to be an abused child as a result of reckless or intentional acts of the parent committed under circumstances evincing a depraved indifference to human life, which result in serious physical injury to the child as described in the penal law, defined in penal law. Or 2, the child has been found to be an abused child pursuant to Family Court Act because the respondent has committed or knowingly allowed to be committed a felony sex offense against the child, and the corroboration requirements shall not apply. Next, the parent of the child has been convicted of murder in the first, second, manslaughter in the first or second, and the victim of the crime was another child of the parent or another child for whose care such parent was legally responsible for, or another parent of, there it is, another parent of the child, unless the convicted parent was a victim of the abuse by the decedent parent, and such abuse was a factor in causing the homicide, or, yeah, so the victim of the homicide was an abuser, basically. Then that doesn't qualify. Or the parent has been convicted of criminal solicitation, and the child was another child of the parent or the child, assault in the second, assault in the first, or aggravated assault upon a person less than 11, and the victim was another child or another child of the parent, and the victim was another child of the parent. The parent of the child was convicted in another jurisdiction of those things. And, so I don't know if you need this "and" for when they're convicted of the things, but anyway, it says, and the agency made the efforts, and the efforts are unsuccessful and unlikely to be successful in the future. When a court has previously determined the reasonable efforts are not required, then they don't have to demonstrate them. Like, the agency doesn't have to demonstrate them. That makes sense. Now, here we go. Repeatedly abused. The child has been found to be an abused child as a result of the parent's acts, provided, however, that the respondent must have committed or knowingly allowed to be committed a felony sex offense, and, isn't that in the last one that I just read? Oh, so this is for repeatedly abused. Okay, so that first thing that I read was severely abused. Now I'm doing repeatedly abused. So the child was found to be an abused child. Okay? As defined in, so the child was found to be abused, and the child then was, okay, so it had to be the child was abused as the result of the parent's acts, or in, I don't even know what these are, but I'm guessing that the first one has to do with the like physical abuse, and the next one has to do with the felony sex offense. Okay. Or the child was returned to the parent, and then 5 years ago, they were found to be an abused child within the 5-year period, or a sibling within the 5-year period. So this one is specifically about abuse, right? Yeah. So abused again. The agency made the efforts, or they're not required. If the court determined reasonable efforts not required. Notwithstanding the provisional law, the requirements paragraph G shall be satisfied if one of the findings of abuse is found to be based on clear and convincing evidence. Notwithstanding any provision of law, the requirements of paragraph G. Where the fuck is paragraph G? Paragraph G of what? Paragraph G of subdivision 3 shall be satisfied if the finding of abuse pursuant to subparagraph I or double I of paragraph B is based on clear and convincing evidence. So now I have to go look for what is paragraph G. So I've located paragraph G of subdivision 3, and it says, an order committing the guardianship and custody of a child pursuant to this section shall only be granted upon a finding that one or more of the grounds specified in subdivision 4 are based upon clear and convincing proof. So that is why that in family court, when they do the order saying finding of abuse or whatever, or severe repeated abuse was based on clear and convincing proof, that's why it has to actually say in the order that it was based upon clear and convincing proof. Because if this ever happens, then a determination of the court in accordance with Article 10 of the Family Court Act based upon clear and convincing evidence that the child was severely abused child shall establish that the child was a severely abused child. Okay? If one of the findings of abuse is based on clear and convincing evidence, the requirements of paragraph G, which is what I just read, shall be satisfied. Okay? Such a determination by the court in Article 10, based upon a fair preponderance of the evidence, shall be admissible in any proceeding commenced in accordance with this section. A determination by the court in accordance with Article 10, based upon clear and convincing that a child was abused. What does the note say? Abused as defined in Family Court Act or Family Court Act, sub 112, as a result of the parents' acts, shall establish that the child was an abused child for the purpose of determination. Such a determination on fair preponderance is admissible. Okay. Upon a finding pursuant to this subdivision that the child has been severely or repeatedly abused by his parent, the court shall enter an order of disposition either I, committing the guardianship and custody or suspending judgment upon a further finding based on clear and convincing, competent and material and relevant evidence introduced in a dispositional hearing that the best interest of the child requires such commitment or suspension of judgment. Now, this is so fucking critical because I did not fucking know this. And this is the only time that I've ever seen in a dispositional hearing a requirement that the evidence be based on competent, material, and relevant. That is literally the only time I've ever seen it. And I'm going to even read it again to make sure. Okay. Upon a finding pursuant to paragraph A or B that the child has been severely or repeatedly abused by his or her parent, the court shall enter an order of disposition, either 1, committing the guardianship and custody, or 2, suspending judgment in accordance with 633. Okay. Upon a further finding, based on clear and convincing, competent and material and relevant evidence introduced in a dispositional hearing that the best interest of the child requires such commitment or suspension of judgment. Where the disposition ordered is the commitment of the guardianship and custody, an initial freed child permanency hearing shall be held pursuant to 1089 of the fucking Family Court Act. And that is why you do not quit the night before the test. Does not forfeit their rights to their sibling contact, inheritance, wrongful death actions. So basically, if this, okay, and the child is deemed to continue in foster care until another permanent living arrangement or an adoption is finalized. When the disposition is to commit the guardianship and custody, an initial freed permanency hearing shall be held. So that's the 30 days. Upon the court's order transferring custody to the commissioner, the attorney for the petitioner, which is the authorized agency, shall promptly serve upon the persons who have been approved as the adoptive parents notice of entry of such order, and advise the adoptive parents that the adoption proceeding may be commenced. The authorized agency shall advise such persons of the procedures necessary for the adoption. They shall cooperate with such persons in the provisions of necessary documentation. Upon the entry of an order committing the guardianship, the court shall inquire whether any foster parent has an interest in adoption. If they do seek to adopt a child, the person may submit, and the court shall accept all such petitions for the adoption of the child, together with an adoption home study, if any, completed by the agency or disinterested person. The court shall thereafter establish a schedule for completion of other inquiries and necessary investigations to complete the review of the adoption, and shall immediately set a schedule for completion of the adoption. In its order, the court shall indicate whether the person or persons were given notice of the proceeding and whether they appeared. The court determines to commit guardianship and custody or to suspend a judgment. So this is either. The first one I was talking about was just commit the custody, and that's why their child's freed for adoption. That's the 30 days. If the court decides to either do the guardianship commitment, I'm going to just say commit, or suspend judgment. So this one is for both. The court in its order shall determine if there is any parent to whom notice of an adoption would be required, pursuant to the DRL. In its order, the court shall indicate whether such persons were given notice of the proceeding and whether the person appeared. Such determination shall be conclusive in all subsequent proceedings relating to the custody, guardianship, and adoption of the child. So again, this is why the parents who were already given notice, like the father or whatever, for the kid born out of wedlock, that person doesn't get notice of the adoption proceeding. If the court has it in its order that the father got the notice pursuant to this proceeding, such determinations shall be conclusive in all subsequent proceedings relating to the guardianship and custody and adoption of the child. A petition to modify a disposition of commitment of guardianship in order to restore parental rights may be brought in accordance with Part 1 of Article 6 of the Family Court Act, where the conditions have been met.